Good evening, everybody. I hope everyone's having a nice week. My name is Jonathan Ginsberg. I'm the host here at the Social Security Disability live stream. And please post your questions and comments. Happy to address any of the questions I get. And we'll go ahead and get started. And we had a question actually that came in well before we went live here. And this is a 60-year-old, 27-year job requiring constant lifting, bending, standing. After 2 hours of pain makes it impossible. A day off, may or may not have back pain, is in daily pain. Is daily pain an assistive device required? And the answer I gave him was no. Basically, at age 60, I think that the grid rules would very likely apply. And the grid rules basically say that at age 55, starting at 55, even if you can do light work, so you need to have medical evidence indicating that you are limited to light work or less. And basically, if you can do light work, you are still disabled, assuming no transferable skills. And the way you get rid of transferable skills would be to argue pain. And I think that the key here would be, number one, it would be really helpful to have some sort of an objective test, like an MRI explaining what is going on in your back that's causing all this pain. That's number one. Number two is a physician, ideally an orthopedist or some sort of a pain management doctor, talking about the limits that you have in terms of your capacity to stand and walk for 6 hours. That's light work. So if you have a doctor saying you cannot stand and walk for 6 hours, you can only stand for 2 hours or 3 hours, then you are limited to light work. And then what you have to show is that there's some objective evidence just explaining the pain. And if that's the case and you testify that your pain level makes it really hard to focus and concentrate, that any skills you might have would be eroded because of that, you have a really good chance at winning. When you're talking about the assistive device, that's really talking more about the listing. And realize that in disability, there are three theories of disability. One is, do you meet a listing? Very hard to do. It's intentional by Social Security, especially when it comes to musculoskeletal issues. They make it really, really hard because that's the number one reason people file for disability. So if you may not meet a listing, the grid rules are great if you were over 50 or over 55 in particular. And then you have something called functional capacity, where you argue the combined effect of all your problems would leave you without the capacity for work. So what I told SA was, and here's my response to him, that after age 60, he's got definitely a strong argument to win under grid rule 202.06. And at that point, I think that it's going to come down to the it's really going to come down to the what the medical evidence shows, and do you have an MRI that shows something significant? Do you have a doctor supporting you? So that is how I would answer that. But I think, generally speaking, a 60-year-old with significant problems that prevent him, and of course you would have to stop working, but I think if you've got some documentation, that's going to go a long way to help you win your case. All right, Jim. I think Jim's been here before. What happens if you're turned down by the ALJ, the administrative law judge? I know you can appeal to the appeals council. Do you start over again? Can you get deferred representation? I would tell you that before starting a new filing a new application, you should have your file reviewed by an appeals council lawyer. Not every lawyer that does hearing work does appeals council work. I typically associate somebody who that's all they do, because it's really a different area of law. It's very much about legal matters as opposed to facts. And so I think it's helpful to have another pair of eyes look at it. So I would do that first. You have 60 days from the date of your unfavorable to do that. I would have somebody take a look at it and email me. You can go to the contact form at the bit.ly, contact Jonathan 3, and I'll give you a couple of names of people you might want to talk to. Now, that being said, if you decide to start over again, realize the implications of doing that. Number one is the earliest onset date you can use would be the day after your unfavorable decision. For Social Security purposes, the unfavorable decision is a thing decided. And once that's decided, you can't go back and say, let's say you got an unfavorable decision on July 23rd. The new onset would have to be July 24th. because everything before July 23rd is incorporated by that prior decision. It was unfavorable. You decided not to appeal, and you basically have to, that's done. You can't go back before July 23rd in this example. And that's problematic in a couple ways. One is your date last insured for Title II disability may have run. That is a problem. You may not be insured. You need to check to look at the decision. It'll tell you what your date last insured for Title II is for disability. That's number one. Number two is if you file right away, it's pretty likely nothing much has changed. So the question is, you file again, the day after your unfavorable decision, and that's your new onset date. What has changed between July 23rd and July 24th? Probably not much. And you know that the new judge is going to look at the old decision. So usually when somebody's reapplying, I tell them, unless you're prepared to wait a year or two so that something new happens, and whether it's you change age categories, you go from 49 to 50 or 54 to 55, or you have a new medical problem, you're going to get the same result. So I would tell you, number one, exhaust your administrative remedy, have somebody look at it at the appeals council. If you don't win there, then you got to really ask yourself, what is new? And as far as getting another attorney, if you file a new case, you definitely get another attorney. It's a new case. If you file an appeals council, if your current attorney does not want to do it, then you would need to ask that attorney to fill out a form called a 1696 Sup 2. 1696 Sup 2. Let me put that in the comments here. Sup 2. This is a withdrawal, and you want to have that person waive fees, because if you don't have them waive fees, let me just stick this in here, then you won't be able to get another attorney to take it. So you need to have your first attorney withdraw and waive fees formally, and that way somebody else can come in and take over at the appeals council level. So again, a lot of things, a lot of moving parts, but big picture is exhaust your administrative remedies. Okay, Rick asks me, what are the chances of a CDR, continuing disability review, for a 55-year-old and over? He's 55, just got approved. Well, congratulations on your approval. My experience would be that it's pretty unlikely you're going to have a CDR unless Social Security sees earnings. If they see you're working and they see ongoing earnings, especially close to, if you once you use up your trial work period months, and remember there's trial work period months you can earn in 2024 $1,110, changes every year. You have 9 of those in any 5-year period of time. Once you use them up, then if you go over SGA, which is substantial gainful activity, or 1550 per month, then you could be in overpay status. So I think that for review purposes, when somebody's working and they're outside of their trial work period, that could be something that could trigger a review. It is also possible that a random, just a bad luck lottery, they could send you a review. But if you fill out the form, typically they send you the short form, which is a 1-page form, no earnings, no significant improvement, then they're not going to cut you off. But I would tell you, percentage-wise, the number of people over 55 who get reviewed is very small, because you're getting close to retirement age, and the mission for Social Security is to try to reduce the rolls of people who are going to be on disability for the next 20, 30 years. So a 30-year-old has a much better chance of being reviewed than a 55-year-old. I'll also tell you that your file is coded, and there's a way to interpret that code, which I'm not going to go into here because I would have to have one in front of me. But you can look up the codes. When you look at if you get a review, you'll see some codes there by your name. You can look those up, and it'll tell you, are you likely to be reviewed? But again, 55, it's just not likely you can get reviewed. My thought. So I think you're probably going to be okay. And certainly, I believe it's to the end of this month, if not the end of this year. The new commissioner has put a hold on all reviews because they're trying to deal with the backlog and the initial and reconsideration. So big picture, Rick, I wouldn't worry too much. And if you do get reviewed, then just fill the form out. And unless you're working or have significant medical improvement, you shouldn't have much of a problem. Because realize at 55, I don't know what your medical issue is, but the grids could apply. It's going to be really, it's more likely you're going to win at over 55. Social Security is not going to spend their time trying to terminate benefits for someone who's much more likely to win if you were to appeal it. All right. And by the way, if you can appeal it, if you get a review and they say they're going to move to terminate, you can ask for a reconsideration and go to a hearing on that. All right. GI Jose. The ALJ asked the vocational witness about missing 20% of work, and the vocational expert said the DOT does not account for off-task missed work. Okay, let me explain this. At almost every hearing, the administrative law judge will have a vocational expert witness there. This is a person whose job it is to describe past work and answer hypothetical questions from the judge regarding your capacity to work given the limitations in the judge's hypothetical. So the judge will say something like, Mr. Vocational Witness, assume an individual who's 53 years old, cannot climb ladders, ropes, and scaffolds, no kneeling, crouching, or crawling. Overhead reaching is limited to, with the right dominant upper extremity is limited to occasional. This individual needs to avoid extremes of temperature or pulmonary irritants. This individual needs to be limited to simple 1 or 2 step entry-level type of jobs. That's an example of a hypothetical. And then typically the judge will keep adding limitations. And one of those limitations is if this individual is likely to miss 15% or 20% of the workday or being off, they call it being off task, or miss 2 or more days of work per month, would that be something that are there any jobs that would exist? Would there be competitive employment? And the vocational witness will always answer with a 15 or 20% off task. There's no jobs out there. That means you're missing more than an hour a day, having to rest or lie down or just not be able to focus on anything. So that's a winning argument if the judge accepts that. Now the DOT, or the Dictionary of Occupational Titles, and you can see it, and I'll put this in the link here, occupationalinfo.org. Let's see. I think it's .org. I'll look it up. Let me double check. I shouldn't tell you that if I don't know. Occupational. Yes, that's correct. This is the DOT. I'm going to show you what this looks like. And you can look at it yourself. So this is the Dictionary of Occupational Titles, and you can go to the search bar and you can type in, let's just say, construction worker. Okay, and the construction labor here would be there's construction worker 1 and a construction worker 2. So let's just look at construction worker number 1, and this is in the DOT. This is what they use. Oh, I gotta switch the screen here. So let's go ahead and switch this to that one so you can see this one, because it can't open in a different window. Okay, so here's the construction worker 2, and here's the DOT code. This is 869.664-014, and it describes the construction worker 1, what this person's job would be. And this is considered to be a heavy job. That H means heavy. GED, this has to do with education, reasoning level 3, math level 3, language level 3, I think. And the SVP, or standard, I think it's specific vocational preparation, that is a semi-skilled job because it is SVP number 4. And SVP 1 or 2, unskilled, 3 and 4 is semi-skilled. I think 5 and above is skilled. I think maybe 5 is, I'm not sure about 5, but anyway, 4 is going to be a semi-skilled job. So if you look at the description here, there's nothing here about off-task, and the DOT does not discuss anything off-task. Realize that the DOT was last updated in the this one looks like, let's see here, this one, it says 2003, but most of them have been last updated, 30 years ago, 35 years ago. So a lot of these descriptions are no longer valid. And in fact, Social Security has taken certain jobs that vocational witnesses used to cite as an example of something somebody could do as an entry-level job, and they say, you cannot consider those anymore. It is outdated. It is inaccurate in many respects. There are certain jobs in here that just do not exist. Typewriter repair person. How many of those jobs really exist? But it's in the DOT because in 1995, there was a job. So the point is that the judge will always ask, because what they have to do is they have to justify using the DOT. They'll ask the vocational witness, what do you rely upon, besides the DOT? And the vocational witness will say, well, there's other specific resources, Department of Labor publications, other things like that. And they'll also say that certain things the DOT does not address, like off-task behavior, that I know as a vocational witness from my years of placing people with disabilities. So that is something that the judge does, Jose, to basically explain how the judge is using that limitation. It's not in the DOT, but it has to come from somewhere. It just can't be made up. So the vocational witness will say that comes from my experience in placing people. Now, Jose asked another question. Do you feel like a judge has to be a doctor to be a judge? No, not really. I mean, I think that, judges are looking at these files and they become knowledgeable, just as I have over the past 35 years, about various medical problems. And you start to see the same things over and over. So, a judge will, have a sense of what it takes for, let's say, a back pain case, a back injury case, what type of evidence is needed to show that person's really disabled. So, for example, if I go into a hearing and I have a client with herniated discs, a herniated disc at L4-5 or L5-S1 that is impinging on what they call the nerve root, or their spinal stenosis causing constriction of the nerves, and the person has radiating pain into the left leg or the right leg, that level of medical information is something that is consistent with a level of pain that would be disabling, and lack of mobility would be disabling. By the same token, I know, and most judges know, that if you have a disc bulge, but there's no stenosis, there's no nerve root impact, that may be uncomfortable at times, but most judges are going to find that is not enough to find that this person can't do any type of job at all. So judges have in their own mind, what level that the medical needs to be to show that there is no way this person could work. If the judge is not sure about it, if the medical record is complicated, if it's an unusual medical problem, the judge can call a medical expert to appear at the hearing and testify. I had a hearing a couple of days ago out of Chicago, and the judge there had a medical expert as well as a vocational witness. And the case was a good case. My client had significant back issues. There was MRIs that showed, scar tissue, all kind of stuff like that. But the judge had a medical expert. He said, I'm doing this because, I want to make sure that, I'm not substituting my knowledge of medicine, from that of an expert. So the medical expert testified about various things, and, the judge basically announced he's going to approve the case. My client, very happy about that, as am I, but he had a medical expert. So some judges will kind of rely on their own experience based on what they know to be disabling, and that, generally Social Security hearings and the results that they know is defendable. If they're not defensible, they're not going to be overruled by the appeals council or district court. But they also have a sense of what certain levels of medical problems are just not as serious. Obviously, there are some judges who have a sense of how much medical severity it takes to win a case, and it's way up here. These are the judges that approve, 25, 30% of cases. They're unreasonable, in my opinion. Where there's other judges, if they approve at 80%, that's also unreasonable. The reality should be around, in my opinion, based on my experience, it should be around 60%. It's right now hovering around 50%. So I think it's lower than it should be. It has been as high as 60% in the past. Right now it's hovering about 50%, which is better than 40%, which is what it was a few years back. So, again, I think most judges have a metric in their own mind as to what it takes. And I think when I look at a case, sometimes people get upset with me, I'll tell you, because I don't take every case that, I get a case evaluation for, because I just know, if I have a 42-year-old with a bulging disc, maybe you win, but it's really, really unlikely. So, since attorneys like me, we get paid only if we win, I can only take cases where I feel there's a reasonable shot at it. And certain profiles I know just aren't going to win. A male, 45-year-old male with fibromyalgia, you're not going to win. It just doesn't happen. It's unfortunate because I think there are probably males with fibromyalgia that are really disabled, but that Social Security won't approve them. So you kind of get a sense of it. You have enough decisions and enough experience and you see enough decisions. I just kind of know, and I suspect many judges kind of feel the same way about it. I'm going to try to have a retired judge who's a friend of mine. I'm going to try to get him on, and I think he'll have some insight on this. Okay. Lil Mom July. I'm not sure if that's Lil Mom July or Lil Mom July, but who knows? But in any case, is there a time frame SSH to pay back pay after winning an appeal at the federal level? Well, I will tell you this. Usually when you win at the federal level, it's going to be remanded back to the judge for another hearing. I know the appeals council has the right to award benefits. Maybe the federal court does as well. It's very, very rare. Usually it's a remand back and you have another hearing. And, people say, well, does that mean that you're going to win? Not necessarily. I mean, some judges get the message. The case has been remanded back. The appeals council has, explained why the judge made a mistake. And judges just in general don't like to be reversed. And so, most of them kind of get the picture. We're telling you, not really saying it this way, but read between the lines, approve this case. Some judges, like, I don't care what the federal court says, I'm going to go ahead and do what I want to do. They may deny it again. So I think you need to look very carefully at the language of the district court order, and which, as you said, at the federal level, I'm assuming you're meaning district court. Look at that order, look at the appeals council order, and see, does it require, or does it send the case back for another hearing? If you're talking about winning a case at a hearing level, the ALJ level, usually once the decision's issued, the money comes in about 2 or 3 weeks. The exception to, and what they do, they have to do what they call non-medical review, where they're looking to see, do you have any earnings or is there something else that's going on that would delay it? I've also had a couple of cases. I had one recently where the appeals council on its own motion decided to review the decision. So basically we got a favorable decision, then we get a notice the appeals council is looking at it. They looked at it for about 3 or 4 weeks, and lo and behold, the money showed up in my client's bank account earlier this week. So it was just a delay, but usually 3 or 4 weeks. Another exception would be if you have an SSI component to your case. SSI is means tested, so they have to look at your income and resource for all the months of past due benefits that apply. That can add another month or two to the problem. Or there could be some other unusual circumstance. I had a case one time with a client who was a green card holder, or maybe had become a citizen, but they wanted to see all that immigration paperwork. The problem is they didn't tell her that they wanted originals. And so the file's sitting on somebody's desk. I called and finally, oh yeah, she's got to bring it in. Well, why don't you tell us this? But they didn't tell us that. So that's another situation. But Social Security can mess it up if things get complicated. So it's just it can happen. It can happen. But hopefully it won't happen for you. Okay, we've got Justin Yu. I have a CE mental exam coming. How to explain my problems and limitations. If the psychologist does not ask questions to give you a chance to explain your difficulty. I think that most of the CE doctors for psychology, what we call them psych CEs, those are usually pretty reasonable. The doctors that do those are practicing psychologists, as opposed to the doctors who do medical, internal medicine CEs, who are typically industrial clinic doctors who do a lot of work for insurance companies to deny claims. So their bias is to find little to nothing wrong with you. As opposed to a psychologist who's usually in practice, and they're kind of geared to recognize that, they're very sensitive and attuned to people having psychological problems. They are supposed to do a history for you. So if they don't do a history, then that would be something I would let your attorney know about. And just, that would be something that if I was at a hearing and my client told me that the psych doctor did not ask for any kind of history, I would ask the judge to give that report, again, assuming it was not favorable, a lot less weight because the exam was too cursory, was not thorough. It's unusual that you would see that. Most of these doctors will do a fairly clear history. If you feel like you want to make sure that your history is recorded. Write out a statement and give it to the, send it to the doctor a couple of days ahead of time. And that way, if you get nervous or if you have problems, coming up with the right words, at that point, you've got it in writing. So that may be something to consider doing. All right, St. Louis Grand, another regular. Hello and welcome, and thank you for coming back. There's a case when the district court judge called out the ALJ for discounting the claimant's insomnia due to lack of evidence and reports of normal gait at appointments. Let's see if there was and the second part of that is, what are some absurd, nonsensical things you've read from ALJs? What are some ridiculous? Okay. The one I always come back to is, I had a case, it was a fibromyalgia case, which are always tough. And the ALJ denied. The ALJ in this case is a very low approval ALJ. It approves like 30% of cases. And he gets appealed a lot. I mean, he denies almost every case, so people appeal him all the time. And, at times he can be a little sloppy, or the decision writer can be sloppy. I don't know if it's him or decision writer, but the decisions can be sloppy. So we appeal them. So in one case I appealed them, went to appeals council, rubber stamped it, went to federal district court. They sent it back to him with very specific instructions that they have got to consider this person's subjective complaints. And the judge was not happy to get slapped down by the district court. And again, that's just, his personality, whatever. So he approves the case, which is cool. Then he writes a 2-page footnote. I kid you not. The first 2 pages of the decision are all footnotes, basically saying that he's only approving this case because the district court is forcing him to do so. He does not believe the claimant, and he's only doing it because he has to do it. And, he just basically had a hissy fit about this, and of course he disapproved my fee contract, par for the course, but eventually got paid on it. But the point is that was probably the most ridiculous example. I've had other ALJs, I've had cases where a person was 56 years old, limited to light work, and the ALJ did not mention the grid rules. Well, you don't have to say the person meets them. You can find transferable skills, but you have to go through the exercise. That, is another example. I've had cases where, I have a case right now where the ALJ, the same one who wrote the footnote, decided that my client's well-documented mental health conditions are not a severe impairment. And why that's relevant is that part of the 5-step sequential evaluation process, is, are you working, is step 1. Number 2, is your impairment severe? And severe basically means, is it documented at all? This guy's got, lots and lots of paper showing it's a significant problem, mental health problem. Judges, it's not severe, and he denied the case at step 2. I think that's clearly going to be appealable, and we're going to appeal it. And again, he'll get slapped down again. But again, I have to be an advocate for my client. I can't control what judges do. So those are some examples of kind of ridiculous stuff there. Okay, let's go back up here. We have Christina, a regular, Villarreal. I hope I'm pronouncing that right. Christina, she is in California, and hello. The big one from Texas is always here. Thank you very much, and I'm glad to see both of you, Big One and Christina. Luis, what is your experience with fully favorable decisions being remanded to an ALJ? I'm not sure if I understand. It's a fully favorable decision by an ALJ. Maybe you mean if you get an approval at the appeals council, or you get a remand at the appeals council or the federal court when it goes back to the ALJ. I would say percentage-wise, about 75% of the time the ALJ will go ahead and read the tea leaves and approve it. 25% of the time, they won't. But that's just kind of a rough guess. Maybe it's probably even higher, but that's I'm just going to give you 75-80% of the time it's going to be approved at the second hearing. Dee Dee just got approved. Will her 7-year-old qualify for back pay as an auxiliary? Yes. Auxiliaries are basically dependents, like children. A 7-year-old would be a dependent. And so your 7-year-old would get an auxiliary payment, which is going to be generally, and it could vary depending on what they call your family max, about 25% of your benefit. It doesn't come out of your benefit. It's a calculation. So if you get $1,000 a month, your auxiliary will get 250. But the back pay, he gets the back pay at the same level, same number of months of back pay that you get. Just to make sure that Social Security knows you have auxiliaries. Vince, how are you doing? Good to see you here. Appreciate you tuning in. Brenda K. Foreman, I was recently approved. I should begin first payment next week. Can now apply for my pension without jeopardizing SSDI. I don't deal with pension law. I think you need to really look at the pension requirements if there's any kind of offset. I don't want to give you a blanket statement. I don't know. So I think I would, definitely take a look at that pension paperwork and see if there's any sort of impact by getting Social Security. Had a remand hearing for partially favorable decision. If the judge set onset date to 1 day after credits expired, I get a fully favorable decision. That doesn't look safe yet. Okay, so Luis had a very interesting situation where the judge approved this case, but did it on the day after, as of the day after, changed the onset date to the day after his credits ran out. So let's say his date last insured was March 31 of 2023. The judge found it was April 1 of 2023. That's just a mean-spirited thing to do. There's no reason for that. I mean, to me, that's just the judge being a jerk, because the judges understand what that means, and by basically giving you that the day after, that 1 day after, he's going to cut you out of all of your ongoing benefits. Clearly, you want to appeal that. I think the appeals council recognized that for the petty, mean-spirited thing that it was. And so you got a fully favorable decision. What will the appeals council, if the appeals council reviews it on its own, could have an issue, but if they've already sent it back, I think that's probably not very likely. So I think you're just, unfortunately, you probably had to wait 3 or 4 years, but you just had a jerk of a judge, and that's unfortunate. Happens sometimes. Do I need to be a citizen to apply for SSD? I think you have to be at least a green card holder. I do not know. Honestly, I do not know. I do not want to tell you. I just don't know. So I don't want to guess. How long will we have to wait for the back pay again? I would tell you, assuming there's no SSI part of this, no complications, once you get the favorable decision, it's going to be about, 2 weeks, maybe 3 weeks at the outset. You should get your money. Saints fan. I think Saints fan has been here before because obviously I'm a Falcons fan being in Atlanta, and the Saints are our big rivals, although the last couple of years, the Falcons have not been pretty much anybody's rival. What's the normal amount of time it takes the judge to make this? There is no normal. I think that, judges are supposed to get the decisions, I would say, on average, about 4 to 6 weeks. It can be pushed to 3 months, maybe. Beyond 3 months is unusual. I've had a few beyond that, but normally that's kind of the outside that I'm seeing currently. And sometimes it's literally, 2 weeks or a week. I've got a couple. All right, Raymond the fan and gamer. Hello, Raymond. My question this week: do you know other SSD personal lawyer? Okay, Mike. Do you know any other SSD lawyers personally? Current lawyers, David Chermel. There's like Walter, not personally. Well, David is very well respected. I met him at a conference in Atlanta. I think it was last November. And I saw him again in Nashville at the NOSCR conference. We had a chance to chat a little bit. Walter, he and I have emailed a few times. I have not talked to him on the phone. I do know a lot of lawyers. There's a listserv that NOSCR has, NOSCR being the National Organization of Social Security Claimants Representatives. And there's a listserv, and people post questions or ask, what do you know about this judge? And so there's a lot of interaction there. So I know a lot of people that way. I've had people call me with questions. They see my YouTube and they'll call me, especially newer lawyers will sometimes call me with questions. So I've spoken to a lot of lawyers over the years, and I know, I've been doing this for a long time. Been to a couple of conferences, you meet people there. And so I know a good number of them. I know, you kind of know who's knowledgeable and well-respected. Again, Dave is very well-respected. Walter, Walter, I don't know if I have not seen him at conferences, but I think he puts himself out there as I do, answering a lot of questions. I have a lot of respect for that. I think, I've listened to his live streams. I've seen his videos. I think he seems to be very knowledgeable. So I think both the lawyers you mentioned, David and Walter, I think are both, very, very fine attorneys. But I do know a lot of different people. I've talked to people, again, somebody will pose a question and, you may end up back and forth and you call them up and you just kind of get to know people over the phone. And I become friendly. I think like I had Stephanie Joy on before. We become friendly. She's got a LinkedIn group where we have lawyers that kind of compare ideas. Got to know her and some other lawyers through that. There's just a number of other people that I've just kind of gotten to know. So yes, so I do know a lot of people personally, not just in Atlanta, but all over the country. I will say it's a very, generally speaking, it's a pretty welcoming group of lawyers. People are willing to help. I think we all have a common goal of getting our clients approved. There's enough good cases out there. It's not cutthroat. I mean, to be honest with you, we get paid a percentage, 25%. It's capped. So it's not like anybody's going to, in a personal injury case, a case could be worth, let's say, $500,000, a lot of money at stake. Social Security, it's you're capped right now at 7,200. It's going to go to 9,200, but right now 7,200. It's not that much money. So one case isn't going to make or break. And so usually I would say this. Sometimes people get frustrated because of the amount of time it takes, and I'll get emails from people. Will you take my case? It's taken way too long, and I'll always ask, who is your attorney? And I'll say, go to your attorney and just talk to him because it's not his fault or her fault. It's taking too long. And sometimes I'll say, you're okay with me reaching out to your attorney to basically tell them that you need a phone call, and just preserve the relationship. Other attorneys appreciate that. They do it for me. I do it for them. There's a few, they're not so nice out there, but most of them are pretty reasonable. And I've gotten to know a lot of really good people, and it's been actually very, very pleasant experience overall. Hello, nice. That's okay. Well, appreciate that. Big part. No need to part. Anytime you have a question, if you turn retirement, will be the same amount. Yeah, I think it's generally speaking. SSD is going to be roughly equal to your full retirement amount. If you get your My Social Security statement, you'll see it, but it's usually within a couple of dollars. So and once you hit full retirement age, they transfer it over to the retirement from disability. That's that form I put on there before. Okay. Okay, right. Raymond's the adult fan of Lego. I remember asking you about that last time. Cancer-free. Which we've heard from before. I'm glad to hear you're cancer-free. This mail processing place asked me to call, so asked for phone application for SSI. SSI, I think what you're getting at is you maybe applied for disability and maybe somehow or another somebody in the Social Security saw that you were also potentially eligible for SSI. For whatever reason, SSI applications are less, it's much more difficult to file for them electronically. And I believe, don't hold me to this, but if you've already got a pending SSDI case, you can't file an SSI application electronically. In fact, there was something that went out from NOSCA today about an electronic system for people to file SSI claims that doesn't work very well. So SSI is kind of behind the times. So my guess is what they're saying is you applied for SSDI, you didn't apply for SSI, but you probably are able to do so, you're eligible for it. So this person said, call Social Security and tell them you want to start an SSI application and have them merged. That's what I think is going on. Johnny Doster, checking this week. Won't be able to watch tonight or next week, so being extremely busy. Okay, that's cool. Well, I appreciate you doing so. By the way, I'm glad you mentioned next week. Next week, I'm going to be doing this on Thursday night instead of Wednesday night. My wife made plans with some friends that it was something that she's been looking forward to. And she's like, do you mind? Can we switch it? I'll put that out early, but next week it's going to be on Thursday night. Obviously it'll be recorded, but not Wednesday night. So I'm glad, Johnny, you mentioned about next week or whatever. Next week is going to be Thursday night. So, but I'm glad that you did check in with me, and I hope you're doing well. Okay. Now this is something that's actually very important. Cancer Free talks about that Social Security sent you an application and said sign it. And sometimes they do this. They want to make sure that you actually filed it. And you've got to sign it and send it back to them. Otherwise, they may dismiss your case administratively. And I've had that happen a couple of times where we filed an application on behalf of a client, and then lo and behold, the Social Security sent my client a copy of the application. My client didn't sign it and return it, and the case got dismissed, and we had to refile. So that can happen. So you definitely want to send that back. Laurie Schmunk. I'm 63 years old, have nerve damage in the lower back and leg. Recently, since pacemaker, lightheaded, backed out, filed for SSDI. What are your chances? I think based on what you're saying and your age, I think it's very, very strong. Assuming you have insurance credits, I think all those symptoms, if they are documented in the medical record at the level you're describing, you have a winning case. Very simple. I think that's a very, very strong case. Rodney, having a good, yes, so when you win a case on the record, if the judge says it, that's a good start for the week. So yes, so far so good. And I know I owe you a call because you've got this, the audio I've got it sitting right here. Just need to do it. So I'll keep reminding me, I'll get to it. You want a copy of the audio recording for your hearing. So I'll get that so you can listen to it. And by the way, what I'm getting at is that the audio recordings that come in a kind of a strange format, and Rodney was one of our clients, and we got a favorable decision, and from a really difficult judge, the judge I was talking about before, and another attorney in the office did it. I can't take credit for it, but we got a favorable decision, and so he wanted the audio, so he's got it on CD, but it's in a format that's really strange. So I've got it sitting right there. I've got to just run it through some software and make it into an MP3 so you can listen to it. That's what we're talking about. Okay, but I'll make sure I do it. It gets crazy around here sometimes. Okay, Susie B. Good evening, Susie. You are 60. You're an educator. Well, good for you. I think I always find that nurses and teachers I really like representing because those are people that it's a calling. You're not doing it for the money, obviously. And, it makes such a difference in people's lives. And I really, did a little teaching years ago when I was in college, part-time kind of gig. And, I know how difficult it can be just from my limited experience with it. I teach a lot of CE, continuing education. This is kind of a form of that, I guess. And so, if you're willing to take your time to share what you know and to help other people, I think that's really admirable. And I think, judges, I think, appreciate it too. So good for you as an educator. That's a very, very noble profession, and you don't get paid enough and don't get appreciated enough, needless to say. All right, cervical and lumbar stenosis, cerviogenic headaches, carpal tunnel, hip bursitis, anxiety, hearing in December, we're having panic attack and hearing. I think that medically, all those things, I think you would definitely want to look at the grid rules. Go to gridrules.net if you'd like. I'll put that on here. I've got another little thing here. Okay, so if you want to look at the grid rules, that's where to look at them. But I think it's 60. There's also something called the POMS, which says that they've got to prove you could basically go back to teaching, which obviously you can't. This is a case where your attorney ought to do a pre-hearing brief where you really spell it out and then practice with you so there are certain questions you're going to definitely get. So if you know these ahead of time, then, you won't be as nervous about it. You're not on trial for anything. You just basically tell a story as to what's going on. But I think you should be fine. I would be surprised if there was any problem with your case. I think that's a very strong case based on what you wrote there, Susie. Let's see. Jenny Jo. Good evening, Jenny Jo. I hope you're doing well. Woody. Woody is 53, 35 years in construction. MRI shows low back spondylolisthesis, severe degenerative disc disease. EMG, which is a nerve conduction study, shows right L5 radiculopathy, which means he's got radiating pain to his right leg caused by nerve compression at the L5 level. C6 radiculopathy, bilateral carpal tunnel, cubital tunnel, etc. So, you're 53, so you have to be limited to sedentary work to meet the grid rule, I think you got a pretty good shot at it. I think you got a good shot at it even if you were 43 with that level of impairment. But I think at 53, I would look at the sedentary grids. And if you can be limited to sedentary work by either a doctor or by your testimony about not being able to stand and walk for more than a couple hours a day because of all this, I think you've got a real good case. So that looks pretty good to me. Simply Stacy got denied for a second time. So I'm guessing Stacy at the appeals council, lawyer sent it to federal court. How long does it need to? It's going to take probably 7 or 8 months to get a decision from federal court. That's my experience. Guilty. The ALJ, I hope you're not guilty of anything serious, guilty. The ALJ asked the vocational expert, 12% off task. He said 4 jobs, then 50% jobs, and said no. The higher percentage, yes, the more off task you are, the less likely it's going to be that you're going to be able to sustain competitive employment. What's really interesting about this, I find it interesting, is that some vocational witnesses will say 10% off task is too much. Others say 15. So obviously the judge knows your vocational witness and knows that that VE is going to say that 12% there's still jobs. I've thought that's an inconsistency that Social Security has never resolved, that VEs, literally, VE in one state says 10%, one says 15%. But I've not heard of anybody using that as an argument. But, obviously you want the judge to look for the higher one is what you really want. All right, Deb is here. I think she's answered the question about the pension. So, depends on the pension. In stage 4 cancer, probably. I think that stage 4 cancer is typically, metastasized or treatment resistant. And so you probably meet a listing or a compassionate allowance. So I think that's pretty likely. Yes, I'm sorry to hear it's at stage 4, but I think, I hate to use the word automatic with anything Social Security. There's nothing automatic in Social Security, but I think that you would have a pretty good argument that you meet a listing. So yes, I think that would be something that would bode very well as far as getting approved. And Deb says, Laurie sounds like a bradycardia. Okay. Hey, Demetrius. Okay. That was the case we won from Chicago yesterday. And I'm very, very glad that we won. And I tried to call you a couple of times after the hearing, kept going to voicemail. But, obviously the judge said we won, so we won. Obviously I want to see it in black and white, but you did a great job as far as your testimony. The evidence was real strong. You put together, you made it easy for me. You put together, put a lot of evidence together, and we had a strong case, and you did great as far as your testimony. We had a good judge, so it all kind of worked out, but I'm very, very happy for you. Okay. Rodney says, well, look, we sincerely appreciate you hiring us. We won. That was great. How can we protect ourselves from people stealing our Social Security numbers due to the data breach? Now we're getting beyond what I do. I think freezing your credit is certainly really, really important. I've got LifeLock myself, so I get these notifications. I would certainly change your passwords, for anything that's financially related. It's a real problem. I mean, there's a big data breach, and I think every person in the whole country's Social Security number got exposed. So I think, freezing your credit is a big first step, and just kind of watch it. And, it's there's no good answer to that other than freezing your credit and just really kind of keeping an eye open to anything going on with you. And like I said, something like I use LifeLock. There's other type of monitoring services that may help a little bit as well. My friend Garrett says, says, good evening, Ginsburgers. I don't know, called me a Ginsburger, but okay. I've been called, somebody used to call me Gainsborough or Gainsburg. There was a dog food, because Gaines something or other, but I used to get that sometimes, or I get Ginsburg sometimes. So I don't care what you call me, as long as you call me. All right. Rajul Hoke. I've been denied Social Security 3 times. I'm appealing it now. I think I get approved. schizophrenia, back pain, and depression. You don't get approved on a diagnosis, Rajul. So it's really about the impact or the practical effect of your medical issues or psychological issues on your capacity to work. And so you need support from that in terms of your, medical doctors or psychologists or psychiatrists that say because of your schizophrenia, you cannot focus and concentrate. You would be, that term, off task for 30% of the day, or that you have hallucinations that make it difficult for you to distinguish between, something imaginary and something reality and something real. That you have, back pain. You've got a herniated disc at L4-5 with radiculopathy, nerve root impingement, or stenosis, or scar tissue. So, I think that is, that's the reason. You don't win by diagnosis. All right, Garrett reminds us all of questions. Put them in the chat. Absolutely. Joel, good to see you again. Good evening. Great. Thank you, Joel. Appreciate that very much. Cancer Free says yes. I think this is the one where the person applied for SSDI first, then had to apply for SSI later, but you can't apply for SSI. You cannot, I don't believe, electronically. You've got to do it by phone or in person, if I'm not mistaken. Brought my green card. First off, that was her first. Yeah, okay, so I think you can have a green card, and that's the first thing they're going to ask. Exactly. Raymond, I still say some of the CE doctors, the bottom of the barrel, take the low fee. Well, they don't pay very much, that's for sure. At least in experience, first in the reports that were pure fiction. I do see that sometimes. I see some of these CE reports that are just really, really, just don't say very much or don't really, give much good information. Again, I will tell you, my experience has been that the psychological doctor, the CE for psychological, typically are usually more relevant. The doctors there are people that are in practice. They make a little extra money doing this, but it's something that they do, and those usually are pretty good. I think with the medical doctors, the industrial clinic doctors, the ones that do just reviews for Social Security or for insurance companies, a little more questionable, I would agree. And I think most judges know that. And I will tell you, I've read a lot of these internal medicine CEs. In fact, I was going to do a video about that. I just hadn't had time to do it. That literally they say nothing. The claimant reports X, and the conclusions, claimant reported X. But it doesn't give any diagnosis or any thoughts about what the person's limitations are. So they can be quite useless. All motor, ALJ hearing. Does it matter if my spine surgery was done before, just booked? Well, my guess would be, the gentleman who just said we had his case yesterday, that was an artificial disc case. Unfortunately, his situation did not work very well. Hopefully you get a better result. Obviously, if you have your surgery, October 15th, no one's going to know how well it turned out. So I've seen situations where the judge would either leave the record open to get the surgery reports in, but again, that still won't tell us what it's going to be like in 6 months, or the judge can simply, consider the case up to the point where surgery has been recommended, which is in itself a comment about the severity of your back problem. If you're in surgical candidate, that's pretty significant. So I don't think it makes much of a difference, but you certainly would want to I would want to let the judge know ahead of time if you have the surgery, a week before your hearing or scheduled for a week after. Let the judge know, because that shows you're being compliant and desirous of treatment. I think that would help, but I don't think it's going to make a big difference in terms of your whether you win or lose. I think hopefully the judge will look at everything leading up to this, and the fact that you're a surgical candidate will definitely help. Lisa, my husband just had stomach pre-cancer surgery, primary arthritis in both feet, lumbar disc issues, degenerative disc, can't take back injections, 58. Yeah, that's a good case, Lisa. I think that he's 58, which tells me the grid rules likely apply. He's got, bad back. He's got feet problems. So that's I think you can make a pretty good argument. Again, assuming this all shows in the medical record, he's limited to light at least, or more restrictive, maybe even sedentary. And then he's got this stomach surgery, can't take injections. He's going to have a hard time focusing and concentrating. You know, assuming this lines up like that, that would be a case I would take in a heartbeat. I think it's a winning case. The dude is back. Hey, the dude was approved in 131 days. You must be living right, dude. All I can tell you, because that's great. It's rare, but good for you. That is good for you. Okay, Kelly, you were working with them. Actually, I have lawyers that I work with, kind of on a, I guess you could say, I mean, I refer out to a lot of other lawyers. If I can't, I just get too busy, can't take them all. So I'll refer out to very few. There's 2 or 3 that I refer out to that I feel very comfortable with. And so, you know, that's what you're talking about there. So they're not employed by me, but these are people that are friends of mine. So I ask about people that I know, and they're people that I just gotten to know, I feel very comfortable with, and I refer out to. How often should you check in? Yeah, you know, I mean, what I do is I have actually a form that every email that goes out is a link to this form. You got a new medicine, fill this form out, it comes back to me. I think 3 or 4 months, you know, there's probably not going to be a lot going on, but I think just, you know, let them know you've got a new medication. Have they heard anything? You know, make ask them, check the ERE docket, to see, is there any activity going on? And if not, check in with the adjudicator. I think, you know, if somebody wants to check in, you know, really by email is probably the best way to do it. I think every 3 or 4 months is okay. That's not that you're not becoming a distraction to anybody at that. I wouldn't call every week. There's not a thing that's going to happen in a week, but you know, every 3 or 4 months I think is okay. And if something's really going on, big changes, you know, more often than that. But realize that this is a marathon. I mean, these cases can take, you know, 2.5 years. So, you know, we've set up in my office. We're still testing it right now. I'm not 100% sure if I like it. A text message update system. So whenever something changes in my case management program, it sends out a text to my client, you know, check your portal, something has changed, or, you know, here's something that you need to know. And we have an email system goes out, just kind of more general. This is what's going on. And then we have, you know, the chat through our case management system. We have texting, we have chat, we've got, you know, all these different things, all different ways to get a hold of us. Because, you know, again, a lot of it's just, you know, quick check what's going on. The case is being worked. It's just going to take, you know, look, right now, initial applications, 9 or 10 months, maybe a year. Some places in like Texas is like 15 months. So there's nothing you can do about it. The only thing I would tell people is once you get beyond about 7 months after you file something, whether it's an initial or recon or even a hearing, you hear nothing in 7 months, you know, look up your congressperson, look up your U.S. senator and say, would you make an inquiry? That's called a congressional inquiry. That gets you bumped to the top of the heap. You'll get some action at that point. So 7 months is kind of my line in the sand for stuff like that. But checking with your attorney every 3 or 4 months, nothing wrong with that at all. Lisa applied. Should we apply? Well, again, Lisa, SSI is means tested. Lisa's the one whose husband has got, you know, back issues and had some stomach surgery, can't take pain medications or shots. SSI is means tested. So if you work, your income would be what they call deemed to him. So you wouldn't qualify. If you have assets, and you can look up SSI assets on Google, but if you have assets beyond, I think, a house and a car, let's say you've got some stocks, or let's say that you've got, somebody's texting me. Let's see if that's important or not. It is not important. Never know. People that know me know not to text me this time, so that's why I always check if I get one. So if you've got assets, you know, beyond what Social Security allows, then it's kind of a waste of time to apply for SSI if you don't qualify. Also, if your, you know, if your onset date is, let's say, a year before you filed, you can only get SSI as of the date you filed. So if you're going for an SSI case where the past due benefits maybe go back into 2023, you know, unless you think that the onset date may be amended, really no point. Yeah, the point I'm making is that SSI can gum up the works a little bit if you don't qualify for it. because they got to go through the same analysis and can delay getting paid by months sometimes. So make sure, I would just say this: look up qualification, non-medical qualifications for SSI, and see if you fit in there. And if you do, go ahead and apply for it. Mark, how have you done with MS and spinal cord lesions? Pretty well, Mark. I know that we're working on yours, and yeah, I think that MS, because multiple sclerosis is a degenerative disease that doesn't get better. There are lesions, obviously, that document the severity of it. My experience is that judges are open to it. Now, realize everybody with MS is not inherently disabled. I've seen cases where it's very mild, but if it's getting worse, and typically it goes to a certain level, and then you stay there for a while, and then you have a flare, I think is what they call it, then your new normal is at a lower level. And so I think it just depends on what the evidence shows about the level of impairment you've got and how severe it is in terms of your functioning on a day-to-day basis. But generally speaking, any medical issue where there's objective evidence, an MRI, something that shows, lesions on the spine, lesions on the brain, whatever it may be, anything objective shows, yes, you've got this problem. This is not, I've got pain, we don't know what's causing it. This is, we have a documented problem that is, based on the medical part, is becoming severe. Your symptoms, what you report to your doctor in your testimony, confirms that you have it at a level of severity that would be disabling from any type of work. So that's how I would answer that. But I think generally speaking, those are pretty good facts there. Thank you, dude. I hope my guidance was helpful. And if you don't mind, I'll put it up here now. If you've not done so already, please leave me a review. I would really appreciate that. That gives me helps me with the search engines. And, everybody knows here, I try to, share what I know. So if this has been helpful, please do leave me a review. Ms. Ortiz says, it's so sad that SSDI decides by age, not the main health reason. I mean, you can win as a younger person, but it's just, reality is if you're under 50, it's a much more difficult process. And, people say, why? And the answer is money, which is the answer to a lot of things. Congress, sees the Social Security trust funds running out of money. They do not want people claiming Social Security for the next 30 or 40 years. Look, the reality is if you claim for 30 years, you're taking out a lot more than you paid in. And so that's their concern. And people who are filing disability are not a voting bloc. So, you're just in a situation where, you are at their mercy, and that's what they do. And Garrett reminds everybody, and I think Christina normally does this. Christina, you're asleep at the wheel. Please like the live stream. Again, leave me a comment. Leave me a review. That would be very, very helpful. Okay. I think we've already answered Kelly's question. Does having federal disability retirement help with getting SSDI? Not necessarily. I mean, I think that any of the other retirement programs like VA disability, federal disability retirement, they are evidence, and obviously some other agency has found you disabled. It's not binding on Social Security. You'd ask, why would you have federal agencies with different definitions of disability? But that's what we got. If yours is a FERS, by the way, F-E-R-S, if that's what I'm saying, you got to be real careful with that, because FERS, there's an offset, I believe, of 100% the first year and like 60% the second year. So the reason that's important is if you have an attorney for disability, the FERS causes an offset, but what that basically means is that they expect you to pay back all the money you got from Social Security for the first year that you have both FERS and Social Security, but they don't let you take credit for the attorney's fees. So let's say that you had an attorney and the attorney got paid $7,200, for that, FERS would say, not only do you have to pay back what you got, but you got to pay back what you didn't get. The attorney got that. Now the next year it goes to 60%. I think it's over, but that can be a really nasty surprise. So if you have an attorney for your disability case and yours is a FERS, you've got a FERS approval, you might want to just make sure you understand the math there. Usually that can be worked out, but that's just something I've seen a couple of times. Okay, your case was remanded to review a few facts and failed enough. Yeah, the ALJ is again, ALJs, administrative law judges, like anybody else, they don't like to be reviewed and reversed. They don't like it when the appeals council or district court comes back and says you screwed up. Because I suspect, and I don't know this, but I suspect that, when their performance is evaluated, if they've been remanded over and over and over, that doesn't look really good as far as their, promotions or their job stability. So I think this is the ALJ doing his due diligence, probably at the request of the appeals council or district court. Okay, so Rebu, I'm 58, applied for Social Security with brain aneurysm, depression, anxiety, my gait problem. Again, all these things, if they're at a severe level, would be disabling. Being 58 really helps, but you don't win on a diagnosis. Having a brain aneurysm is inherently a serious problem. But, if it was clipped and, you were only out for a couple of months and there's no long-term effects, that may not be a disabling condition. Depression can be mild or severe. Migraines, hard to prove how often you have them. It's self-reported. Osteoarthritis, again, how severe? Gait problems, how severe? Would it prevent you from going back to past work? So it's really about the severity of these problems, not the diagnosis. All right, Jen, my paralegal, Glosters. We got Ginsbergers and Glosters. I think it's, Jen, you're going to confuse everybody here. Glow Ginsberg Law Offices. We have one of our websites is Glow Law, and so that's why what she's mentioned, Glosters. And Jen got back from, I think one of her children had practice tonight, so I think she got back from that. Okay, so Sally is telling us that the case was remanded to the judge who's getting more medical records. That was her first comment. And she's saying that the judge says might be able to avoid a new hearing and be found favorable. That's good. That's a judge who's reading between the lines. Case was filed November 2018. Okay, you see how long it takes. We're now, in September 2024. So we're going on, 6 years, over 5 years. Ridiculous. Dee, still waiting. Think my chances are good. 59, cervical lumbar strain, Parkinson's, 3 slip, 2 bulging, degenerative disc disease, physical CE last week. Again, Dee, it just depends on how long it takes the adjudicator to get the case, the file together. I would tell you, generally speaking, initial applications, 9 to 12 months, recon, 8 to 10, 11 months, hearing 5, 6 months. So depending on where you are on that, that's kind of the general time frame, but there's no specific limit. Okay. Marlo, hello, Rebecca. Can workers' comp after you get fired? All right, this is, I'll tell you, Marlo, my wife does comp in Georgia. Comp is state specific. And I will, and obviously I do some videos for her and I hear a lot about her cases. And so, yeah, first of all, if you're fired, you're on comp and you get fired, being fired does not eliminate your comp case. It survives your being fired. If you file after you're fired, it's going to be a more difficult argument because, the employer's defense is going to be, that you only applied for long-term disability, for a workers' comp after you got fired. So it's better to file for it before you get fired. But being fired in itself does not terminate your workers' comp case in general. That's I can't speak to other states, but I know that would not be the case in Georgia or most other places. And I know in the long-term disability world, I've got a friend of mine who does long-term disability work, and we were talking about this the other day, and he made the good point that, if you file for long-term disability, do so before you get fired, if you see the writing on the wall, because after you get fired and you file for it, it's much, much more difficult to win. Daryl Tinsley, original music and cover, okay? Have an ALJ hearing on January 5th. It's already scheduled? Wow, that's really bipolar, rectal bleeding, ew, that does not sound comfortable at all. So, again, I think that when I look at it, I look at everything through the lens of how it affects you at work. And so bipolar, can sometimes be controlled by medicines, sometimes not. So how often is it not controlled? And when it's not under control, what does that mean in terms of your functionality? The same with the rectal bleeding. Is it something that is once a day? Is it 3 times a day? Is it it's coming out of the blue? Is it to the point where you've got to change your clothes 3 times a day? The practical, what is the problem? What is the problem it's going to cause in terms of your work capacity and work reliability? So again, not just a diagnosis. Dude, well, thank you very much. $20. I appreciate that very, very much. That was very generous of you, dude. And I will definitely, I don't really drink, but I will raise a soda water to you. And sounds like that would buy myself and a couple of other people in the office lunch, which would be much appreciated. Thank you. All right. Christina was talking about responding to Lewis from before. Okay. Okay, good question, Elizabeth. If your letter says you're going to be reviewed in 3 years, is that likely to happen right at the 3-year mark? Probably not. That is kind of a guideline, but I don't ever see, I don't think they've got a computer system that automatically kicks out reviews at 3 years. It's going to be in the 3 to 4 year range probably. And again, it could be that we have one of these stays when it comes to reviews, so it may be longer than that. Stephanie, Deb, okay, Stephanie speaks highly. Okay, well, I speak highly of her. She's, we become actually, it's funny, with everything, not just with YouTube, but with, Zoom and all the different video chat, you get to know people you've never met. I've never met Stephanie in person. And, I was hoping she was going to go to the convention in Nashville. She didn't. And maybe at some point we will actually, meet. I've met some people actually that have come through Atlanta. Atlanta is there's a lot of conventions here. So I've got a chance to meet a bunch of lawyers in Atlanta and also again in Nashville. But yeah, Stephanie's great. And I've had her on. We're still kind of trying to work through some technical stuff with her microphone and so forth, because we got a lot of delay, but I'll get her back. But she's, Stephanie's a solo practitioner, really cares about her clients and really knows her stuff. So, that's the highest accommodation I can make. Does a green card holder who's diagnosed with bipolar, COPD, have the right to? Again, you have to win, but I think having the green card, I believe you can pursue it, but you still have to win. You got to prove it. It's not something that Social Security has to prove. You've got to prove it. All right, Carrie. 51, multiple health conditions being in recon for a year. Section person that writes context. Thank you. Okay, you sent your elected rep a message, received notification, initiated congressional inquiry. Never would have done that. Okay, well, good. That's part of why I do this, is I want people to know that you got to be your own advocate. And just like Carrie's talking about, I told I mentioned this in a previous video or live stream that if it goes beyond 7 months, go to your congressional, I like the U.S. Senator's office and say, make an inquiry. That's, they work for us. It doesn't seem that way sometimes, but our elected representatives work for us, and, they like to be able to do stuff like this because it's easy and it makes them look good. So if you write them and say, I've been waiting for 7 or 8 months, I'm really suffering, and they, write one letter, one of the staffers writes a letter, and the next thing you're getting all kind of attention. They look really good. You're happy. They're happy. It's a win-win. So yeah, use them, absolutely. But I'm glad, Carrie, that it worked. Rick and Christine's, who would I recommend in Cleveland, Ohio? I think Michael Liner might be there. Let me just see here. I realize that Social Security disability is now pretty much in, let's see. Yes, Michael. Okay, yeah, Social Security disability is pretty much virtual at this point, so you can get an attorney any place. It doesn't really need to be any place. If you wanted a live hearing and want somebody in Ohio, there's a very, very good attorney named Michael Liner, Liner, linerlegal.com, and tell him I sent you. But I think he does a really good job. He spoke at the NOSCR conference. He and I have corresponded a little bit. He does a lot of videos as well. But if you're looking for somebody in Cleveland, that would be probably, and you want somebody who's with a let's say an in-person hearing, I'd say call him. All right, Garrett says the dude. Okay, far out. I think we're getting into what I keep forgetting the name of that movie. What's now I'm thinking about it. So let me look it up here. I think Jeff Bridges was the dude. The Big Lebowski. The Big Lebowski. So The Big Lebowski was the movie. It's a kind of a cult favorite. I saw it one time. Yeah, it was okay. I didn't like jump out at me as being like one of these classics, but maybe if there's some botanicals involved, it's better. I don't know, but who knows? Okay, Daryl Tinsley's cover songs. 2 psychiatrists RFC or functional capacity forms in your favor. You have an attorney. You're 50. You have an attorney. I don't think your attorney's 56. You're 56. The FCE says you'll miss 4 more days of work. Yeah, that's really good. I mean, I think that your age, supportive medical support, supportive medical documents, a functional capacity form, and it sounds like you've got some significant issues. I would say that that sounds pretty good. And obviously the fact that you had an attorney took it, that's also cool too. I think it's got a good case. Okay, so again, Deb's replying to Janena about, do you have your credits? How long should you get your money after you get approved by the judge? Again, generally 2 to 3 weeks, but it could be longer if there are complications. In your award letter, it says you'll be reviewed 5 to 7 years. You're 60. Will they review it? Probably not. Realize for Social Security, they have limited number of people. They have fewer people now than they had 20 years ago. We got all the baby boomers retiring. They're really busy. So, if you're trying to allocate resources, are you going to review somebody who's going to be in retirement in a few years, who's 60, who's going to, clearly have more ways to qualify using the grids and the PALMS rules? So, if you challenge it, you're probably going to lose. Or do you go after somebody who's for review, who's 35, who maybe got approved, but maybe had a judge with an unusually high approval rate, or somebody who's maybe more resilient that's likely to get better? That's where you're going to put your resources. They're going to put the CDRs to people in their 30s, 20s and 30s and early 40s, not somebody who's 55 or 60. So I think that's just a numbers thing. Okay. YouTube user has hearing in 2 months, meets the grid rules of 55, severe stenosis with Parkinson's. Could you get approved before? Yeah, you could. I mean, I think that, this is where I would write a brief and ask the judge to consider an on-the-record decision. So I think absolutely, I think you could get approved. Don't assume you will, because it doesn't always happen, but you certainly could. All right, now Garrett's going a little crazy with the memes here. I don't know, what do they call them? The icons or emoticons? I don't know what do they call them, but he's going crazy with them. I've never seen those before. That's kind of a cool one, like that. I don't know what that so much is, but that one I like. That's a good one. Okay. I've been applying with this mail processing place. I thought it was a disability lawyer. Mail processing place. I think that what you want to find out, you got to find out who's the person who's representing you. You don't have to be a lawyer to represent somebody in Social Security, which means that somebody in a mail processing place could say, I can help you. You got to ask some questions here, because, you may be going down a road with somebody who doesn't know what they're doing. Maybe they do. I don't know. But you got to find out, maybe ask for a copy of the 1696, the appointment of rep form, ask for a copy of your fee agreement, and see what it says. See what it says. But, you do not, it's not like, again, you don't have to be a lawyer to do this. You can be a non-attorney rep. And there's some non-attorney reps who do a good job. There's some who don't, just like there's some lawyers who don't. But, I think there is a certification, I think it's called an EPE or something for non-attorney reps, But literally, if you look at the forms in Social Security, you can have a friend help you. So, you don't know who it is. You just need to find out. St. Louis Grand. Hope your friends. Yes, we're going. I think I don't know what. Maybe I think it's a play of some type. We have a local, community theater, and so they do these plays. And so I think I don't know which one we're seeing, but anyway, she really wanted to go, and we had some friends that were going that day. So I said, okay, you got to peace in the house is very important. I will tell you. So you got to do what you got to do. So I figured, you know what, I could taught her on a Thursday, and who knows, maybe we'll find Thursday we got more a little different crowd, more people. Who knows? Interesting. I can be exposed to more people, which is a good thing. What are some ways you don't challenge the grid rules? What are some ways of challenging the grid rules other than medication side effects? I think what you mean is how do you argue, because 202.06 says you're limited to light, and you win if you have no transferable skills. And so I think what Rock is asking is, how do you prove that you don't have any transferable skills? Okay, couple of ways. Number one, as you mentioned, medication side effects, that can do it. And transferability of skills, let me go into that a little bit. When you work at a job, especially a skilled job or even a semi-skilled job, you may pick up skills, and skills are not like, I'll give you an example. I can't really think of a good example, but a skill would be something like doing inventory, managing people. It's not, a skill is not being 6 foot tall. I mean, it's got to be something you've learned from your job. So, typically the skills, like I said, managing inventory, managing people, filing reports, project management, these are all skills. Maintaining file system, these are skills. But because they are skilled by definition, you've got to have the ability to focus and concentrate. So if you have a medical problem that causes severe pain, you can legitimately argue that because my pain is at such a level, I can't focus or concentrate. And that, for a substantial part of the day. And so what that means is those skills you may have had, being able to do inventory, whatever, you can't do them because if you're in just chronic pain, you have severe migraines, you have medication side effects that make you dizzy or nauseous, you can't focus on anything but your nausea or your headache. You can't really think about doing inventory. So that's how you get rid of the transferable skills. And so medication side effects are one, severe depression could be one, mental health problem, migraine headaches could be one, nausea could be one, anything that interferes with your focus and concentration that would, allow you to use your skills in a work environment. That's how you go after transferability of skills. And at 60, realize that 202.06 applies at age 55. And I don't need to show it to you because I think that might be easier to show you than to just talk about it like this. Okay, so we are 202.06 says you're 55 plus, a high school grad or more. Make this a little bit bigger. And does semi-skilled or skilled work background skills are not transferable. So you've got to prove to meet the grid that your skills are not transferable. If you show they are not transferable, you are by the grid disabled and you win. All right, great, that's the ideal. So you have to show that there's a reason why you cannot use your skills. And it's typically because of attention and concentration and focus, memory, emotional stability, things like that. That would be the reason why you could not use those skills. Laurie, my pleasure. Christina comes in to like, share, comment, subscribe. Absolutely. Mr. Toast. I'm in California, got approved August 21. How long do you see back pay? I think, again, you should be getting it in the next week or two. Who is a good candidate? You've got it for SSI, not SSD, but SSI. You have to be very, very low income, no household income, very little household income, and no assets. So you cannot have a stock portfolio of $50,000. You can have, I think, a house and a car, but you can't have a rental property. you cannot have assets worth more than a couple of $1,000s. So it's really for people who really have little to nothing. And the biggest problem that runs with SSI would be if you are married and your spouse works and that spouse is earning $30,000 a year, let's say $40,000 a year, they deem that income to you. And so that disqualifies you. Now, they did recently change the SSI rules to now not count, I think, food and shelter or food and clothing from family members, things like that. You can look up, SSI deeming rules, DEEMING, or SSI, asset rules, SSI deemed income rules. It'll tell you, it can get kind of confusing, but generally speaking, if you're indigent, you don't have any money, that's when you'd really look at doing SSI. Okay, Katrina, I have chemo brain. My daughter tried to help me get a new ID or something, and she couldn't even do it. It was for a new login or something. Not sure. When you say a new ID, do you mean to log into your My Social Security account? That may be what you're talking about. And so, I don't know if I guess you can call if you're prepared to wait on hold, but, chemo brain can be disabling. I've had a lot of clients who take, these really powerful chemo drugs and it messes up their mind. They can't focus and concentrate. So, that could be helpful. And, if you're not sure about if you're not clear about being insured, I guess when you call Social Security at 800-772-1213, 800-772-1213, you can ask them, are you insured for SSDI? And if you've worked, let's say up until 2023 or 22, your insurance usually follows you for about 5 years after you stop working. So that's another way to do it. And Deb's pointing out, Charles is the one, I think, with the stage 4 cancer. Compassionate allowance, that's also, and she's correct, this is a TERI case, a terminal illness case. So look up TERI cases, TERI. What I would do, cancer-free, I would call Social Security. I think that you're getting a runaround. Something does not smell right here. Call, if you can, get the adjudicator on the phone and ask them who they show as your representative. Or call Social Security, call the 800 number, 800-772-1213. And just, stay on hold, find it. Tell them, you got somebody representing, you know who that person is. Who is it? What is their contact information? You have a right to find that out. So I would definitely find that out. That is not, Katrina, did I call you something else, Katrina? I'm sorry if I mispronounced your name. Katrina, I think you had the question about the chemo brain. Okay. Yeah, I think Deb's got good advice. Go to the Social Security office, or call them. But maybe can make an appointment and go in. Just look at it. So that might be even better. You get copies. I'm 50. My review period is 5 to 7. The onset of 2019. What are the chances for review soon? It kind of depends on how they coded it, and how severe your problem is, and also, are you working at all? Have you tried to work? So I think that, once you're over 50, it goes down, I believe. And the grid rules do apply to age 50, but they apply only if you're limited to sedentary work and you have a physical problem. You don't use the grids for mental health problems, only for physical medicine problems. Okay, Rolando, I suffer from fibro and depression, denied adhering. Judge says I can't work my previous job, do another job, 52, what happened? Okay, well, all right, Rolando, very, very good question. Thank you for asking it. I think part of the problem here is that fibromyalgia and depression are not exertional impairments. Unless you have evidence to show they limit you physically, pain and depression are not necessarily exertional. Depression is certainly not. So, the judge says you could not work your past job, but they say you could do another job. And it doesn't mean that there is another job out there, they're going to find for you. It just means that the vocational witness felt from, or answered the judge's question, that you could do another job. But I don't know if the grid rules applied here unless there's evidence to indicate that the fibro causes physical limitations in terms of sitting, standing, walking, lifting, things like that. And again, as I'll tell you, Rolando, and I'll just be straight with you. Males have a really, really hard time winning fibro cases. I've never won one. 30 years. And I can't say I've done a lot of them, but I've had cases I thought were winning cases. And I can't take them anymore for that reason, because they just don't get approved. Hard enough to do it as a female, but males don't do it. Okay. What does it mean, Sweet Candy says, when Social Security tells me my case has not been assigned to an adjudicator? This is before you hired a lawyer. It means that the Social Security office is so backed up that in other words, you have people at the Social Security office who man the phones and who, take information in. Then you have people that are called adjudicators who actually do case development. They request medical records, they look at the files and make decisions. Well, there's a certain number of them. They only have a certain number of cases they can handle. And if they're overwhelmed because they don't have enough, there's not enough of them and there's too many cases, the case sits in limbo for months and months and months, like in Texas, for over a year, before they've even assigned an adjudicator. So no one's even looking at it. I mean, it's just sitting there. That's where you contact your congressperson, because that's ridiculous. It should be sitting there for, a year or 8 months. I mean, I think that, 2-3 months is about as long as it should sit, but that's not the reality here. Okay, my lawyer did an appeal with the appeals council. Okay, again, the new rules you're talking about are the past work rules. So you said the judge found you could not do past work. Well, that's what the new rules will help you with. You said thanks. I think you're talking about Greg Brinkley's the Yoda. I'm a friend of Greg's, but I'm not the Yoda. Greg Brinkley is the disability Yoda. He's got a YouTube channel and he's got a website and so forth. But if you're looking for Greg, I'm not him. He was on here a few weeks ago, but nice guy and very knowledgeable. And I tell people to call him frequently, but I'm not him. But anyway, I hope that what I was able to tell you was helpful. I really don't understand your question. Well, don't want to skip over your question. Okay, so you've said to me, Cancer Free, that a mail processing place, not sure what that is, sent you a paper that said they needed a signed application. And SSA, my town, said they had a signed application. I'm not sure where to go. So what I'm saying to you, and I think Deb Lindley said the same thing, something isn't adding up. Something's not adding up. You've got somebody who's apparently representing you, but you don't know who this person is. You know them as a mail processing place. That is usually not a good recipe for an effective Social Security representative, a mail processing place. When I think of mail processing places, I'm thinking of either, somebody in a mailbox and more type of store or the post office, but they're not people who do this on a regular basis. So they're telling you one thing, Social Security is telling you something else. Go to the source is my point. Go to the source, contact Social Security, make an appointment, go down there and look at the paperwork and see who is representing you. Get a name of a person. The mail processing place is not enough. You got to get a name. You got to know who this person is, what their experience is. And you then have to decide, do you want them to continue? Okay. Let's go back here. Any difference I should be aware of in applying while living in Mexico? I've reached out by email, phone call schedule. No, I mean, the only thing I would tell you would be, if you're going to the doctor in Mexico, are the records in Spanish or in English? Do you prefer to, because Social Security will give you application, they'll process your case in Spanish if you wish. So if you choose to do that, that would be what you could do that. I've actually got in my office now, I have 3 bilingual people. We're trying to expand that part of our practice a little bit. But they will actually do it in Spanish. I'm gonna have to get an attorney who does Spanish speaking to do the hearings, but I've got the staff to do it. So, but I think as far as anything else, you should make sure you've got a good way to get mail, and that you're going to the doctor and that the records are able to get to Social Security. Terry says, what if you're diagnosed with diabetic retinopathy? You do not want shots in the eye or laser treatment that hold it against you. Already applied years ago. Okay. Very good question, Terry. The answer is no, they will not hold it against you. Social Security there is a ruling, I don't know off the top of my head the number, but there is a ruling that says that failure to follow prescribed medical treatment is not held against you if you have a good reason for it. So, for example, not wanting to get shots in the eye because of concern about pain or concern about side effects or possible loss of vision, that is a perfectly good reason. I had, again, the gentleman who was here before, he had a doctor, he had the artificial disc surgery, but before that he had a doctor that said, I'm recommending a fusion. And he said, no fusion, I don't want, it's too dangerous. They don't hold it against you. So no, they will not hold that against you, but make sure that the doctor documents why you were refusing that and you make note of it as well, so that if you're asked about it, this is not a minor procedure. I know my father-in-law gets those shots, and it's I can't even imagine having, and you're not asleep, then all of a sudden you're looking up and then somebody takes a big needle, sticks it in your eye. That can't be very pleasant. So you could have psychological reasons not to want to have that. So but it will not be a problem. There is a law very specifically. And being 59, you're diabetic. Retinopathy, obviously that's going to limit your vision. And the if you've got neuropathy, you said foot neuropathy and peripheral artery disease, that can affect you physically. So you could argue the grid rule 202.06 because you've got the retinopathy and the neuropathy in your feet. Problems walking and standing. Walking and standing for less than 6 hours, you meet the grids. Or you're assuming that you've got that way to get rid of the transferable skills. So yeah. But yeah, I think, Terry, you've got a pretty good case there. Diabetes is insidious, as you know, and if you've got to the point where you've got retinopathy and neuropathy, that's pretty significant. Woody, thank you much. Thank you to me. I'm going to continue to work the wheels fall off, but I'm going to definitely contact you at 55. Okay, well, I think that's a healthy way to look at it, Woody. I think that, anytime you can work, you should work as long as you possibly can. And certainly if you can make it to over 55, your chances of winning go way up. Okay. Another really good question. If a person was denied in the past and the part of the denial was based on the 15-year rule, can that claim be? I don't think so. That's a very good question. I've not seen anything that says that it could. I think that the way Social Security wrote that was that the 5-year rule was not retroactive. It only applied to cases pending as of the time the rule changed. So, if you had let's say, a decision that was being written, they would have to go back and maybe review that decision. But if the case is over, it was 3 or 4 years ago, no, I don't think you can go back and reopen. Any input on Savannah ALJ, Linda Taylor? Not personally, I don't know Judge Taylor. Look up, there's a number of different sites you can go to. Atticus has one. Let me just take a quick look and see. I'll show you what that site. And it's not new, but I still use it because it still gives me some useful stuff here. So just kind of general stuff. So I'm going to show you where I go many times is the Atticus site. This is from 2022, but it's still pretty reasonable. So we're going to look for Judge Taylor. I could type. Linda Taylor. Okay. Judge Taylor, according to this in 2022, had a 41% approval rate, denied 59% of cases. 41% is a little low. The average is about 48%. So based on this, and again, you can look, there are other places to look, her approval rate's a little bit lower than average. Not ridiculously so. Now, again, when you get down to a 35% judge or a 32% judge or a 16% judge, that's when I get really worried. 41%, not thrilled, but it's not the end of the world. That's what I would tell you. But you're going to have to prove your case. That's the reality of it. That's where I go. But just look up Social Security Disability Judge approval rates, and you can find a bunch of different sites. Lauren tells us she's been dealing with seizures and migraines daily. Doctor's board certified neurologist has me listed with 4 moderate 4 mark limitations. Yeah, 4 mark limitations along with visits very likely is going to be enough, because marked limitations, if you have enough for those and they're in something significant, like, attention and concentration, persistence and pace, you know, carrying out simple directions, things like that, they're marked. That's a winning argument there. Mocan. Hi, Jonathan. SSDI hearing for PTSD, 100% permanent total military VA, exposure to death, medications for nightmares, sleep. How's my chances? Again, it's going to depend on what the record says. Depends on winning or losing. I would tell you that in general, my experience has been that military PTSD cases, I don't think they get approved as frequently as they ought to. I think there are some, for whatever reason, some disability judges seem to think that, exposure to death and destruction, all that's, all the things you see in combat are part of the job. I don't know the logic of it, but I just don't see enough of those. Some, they do get approved sometimes, but the lower paying judges are not as likely to approve those cases. That being said, if it's personal to you, you saw death up close, you've got documented for a long period of time at the VA, all these things. I think you got a chance. I mean, absolutely got a chance. I mean, and you testify, that you are fighting it, you're being compliant. The VA, if that's where you're treating, gives you all kind of medication. You may have some medication side effect issues. So I would say, generally speaking, what you're describing, I think, is very likely disabling. Again, my experience has been that military PTSD, whether it's combat or sexual assault, they get approved at a lower percentage than I would think is reasonable, personally. That's just my observation. Jake, thank you. My videos have helped a lot. Applied November 21, approved last month in recon. Move your onset date to your 50th birthday. Yeah, and that happens a good bit. But that's good. Look, a bird in the hand's worth two in the bush. So absolutely, I'm glad that the videos helped, and I'm glad that you were approved. And again, changing the onset is something they will do periodically. And you can appeal that, but you have to make a decision whether you want to do that. This is Deb responding to Janana about SSI. And again, I would just tell you, look up for SSI, go to Google and type in, income or just type in resource limit for SSI, and then maybe household income limit for SSI. And you'll get pages from Social Security's websites. There'll be other, entities that have a lot of written stuff about this, and you can find out what you need to know about the requirements there. Any advice? This is Mose with the PTSD. I think one thing I would do is keep a diary of symptoms. So if you're having these terrible nightmares, sleep issues, keep a diary of it, and talk about how it affects you. Non-restorative sleep makes it really hard for you to be effective at work. Maybe get statements from former coworkers that talk about some of the issues you had to deal with because of this, and try to be as descriptive as possible. What triggers do you have? Is it bright lights? Is it noise? Is it males? Is it females? What are the triggers? And just try to be as specific as you can to show that this is what causes these problems. These are the triggers, and this is what happens when I have an episode. And what you do, you just have to leave the place. Are you have anger control issues? Just really paint a picture as to what it all means. I think that would be what I would tell you. Okay. Donna, is there an RFC form? I want my primary doctor to complete medical records, but inaccuracies are not detailed enough. I will show you a couple places to get them for free. And here is one. Let me present this here. And she calls them RFC. I call them FCE forms, functional capacity forms. But if you go to this website, I'll put this in the description. Or this one. I've got a second one here. And those two places that I'm showing you have free RFC forms or functional capacity forms. So that's where you can go, is the two places I put in the put in the comment section there. So that's where you can get them. Marlowe says, can a person stay in workers' comp? Yeah, I mean, you can. Like I said, being fired in most states, I'm assuming, I've not studied the workers' comp law in every state, but generally speaking, being fired while you're on comp, it does not eliminate your comp. In other words, it doesn't make any sense that an employer could eliminate, your comp case by firing you. You're still in the comp case. In fact, in Georgia, and I'm speaking only about Georgia, when my wife has a comp case and the person gets fired, she actually thinks it's an advantage in many cases, because one of the issues in a comp case is, at least in Georgia, the way Georgia law works, is the employer insurer, can find a job for you and basically try to cut your benefits off. We found a job this person can do given their limitations. Well, if they fired you, they can't do that, right? They can't find a job for you because they fired you. So there's no job available. So it actually limits one of the defenses of the employer insurer. In Georgia, and I realize I cannot speak to, I'm not a comp lawyer. I don't play one on TV, and I cannot speak to workers' comp law any place, even in Georgia. I mean, again, I know what I know because I've just absorbed it, but I haven't done comp in 30 years, and so I would not be the one to ask about that. But I think that's, in general, I don't think being fired is going to be an issue. Did the grid rules change at the age of 60? They do not. However, one thing that does change, which is really important, is something called the POMS rule. I'm going to show you that here. So the grid rules basically go to age 55 and over. But then when you hit age 60, here's what happens. And this is something called the POMS, or Program Operations Manual System. And the link, I'll put the link in the chat here. You can look at this. And what the POMS do is they talk about transferability of skills. Remember, we talked about the grid rules and transferability of skills. Well, if you look down here, and it says, if you are age 60 or older, okay, then with the grid rules here, there's a standard here called the very little, if any, vocational adjustment standard. Make that a little bit bigger so you can see it, okay? And basically what that means is that when it comes to transferability of skills at 55, they're going to look to see, do you have any skills that would logically transfer to any job? So let's say you were working in a warehouse and you did inventory, for auto parts inventory in a warehouse, and that was the skill you had, as one example. Well, at 55, the vocational witness or the judge could ask, if you have, would that inventory capacity work if you were moved into a warehouse of flowers, let's say a garden, a nursery where you're doing inventory of flowers. It's inventory, but one's auto parts, one's flowers. Very different considerations. Flowers are are perishable. Auto parts are not. So you've got to be worried about more things in a flower inventory than you would in an auto parts inventory. I'm just making this up, but that's the example I'm talking about. But transfer. So if a judge found that you had transferability of skills to do inventory, the vocational witness can say, well, there's jobs here that are lighter, that they're doing with flowers and not auto parts. Let's say auto parts is heavier because it's metal, whereas flowers are lighter. So there's a transferable skill. The grids don't apply. At age 60, however, this standard changes, the very little if any vocational adjustment standard. So you could argue that auto parts are so different than flowers that there would have to be a significant vocational adjustment. To do inventory in a flower nursery, I would have to learn about temperature control. I'd have to learn about, when the flowers start to go bad. I'd have to learn about, refrigerated trucks, things that I would not have to deal with in an auto parts store. So my point is simply that this standard applies at age 60, that makes it much more difficult to find transferability of skills at age 60. So the grid still applies, they do at 55, but the standard at 60 says that the transferability needs to be pretty much very little vocational adjustment, which in practical terms means you have to show you've got to be able to do your past work or something extremely similar to it. So it's easier to meet the grids at age 60 than at 55. It's still much stronger, a really good argument at age 55 or 56, but at age 60, it gets that much stronger. So that's really the answer to John's question. The grids don't change, but the transferability of skills analysis does become easier or becomes more difficult to find transferability of skills once you hit age 60. And I think that, again, you can read through, there's some different requirements there, but that's basically how this is. They give some examples here of how you do things. So I think there's a carpenter in the construction industry versus a carpenter doing something else. But you get the drift. It's just easier at 60 than it would be at 55, but still pretty easy at 55. I win a lot of cases on the grid rules. 202.06 is, I'm going to get a big poster that says, I love 202.06 because I win a lot of cases with that. Levi Farr. I have Ehlers-Danlos syndrome, meet every criteria for listing 1.118, have an orthosurgeon offering a surgery for my shoulder joints, recommended against an x-ray shows subluxing. All right, Ehlers-Danlos, if you don't know, is hypermobility of joints, and there's sometimes other issues that go along with it, but the POTS a lot of times goes with it, which is where your blood doesn't, you lose consciousness because the blood doesn't get around your system fast enough. And there's some other things that go along with it as well. But Ehlers-Danlos is hypermobility of joints, where basically you could do like that and your joint pops out, where you stand up too quick and your joints pop out. In a serious case, it can be very, very debilitating. And that is one area I will tell you, I've won a number of Ehlers-Danlos cases for people in their 20s and early 30s because there's really not much they can do about it. And when you have your joints popping out just with minimal activity, very hard to, do anything safely. So if you've got, let's see, you mentioned listing 1.118. Let's take a look at that. I don't have them all memorized, so I don't know. So let's see. So this is abnormality of a weight-bearing joint. I don't know if I've used 1.18. Let me show it to you here. I don't know if I've ever used 1.18 for Ehlers-Danlos. I usually argue functional capacity, but I guess you could. Abnormal motion instability of the affected joints and anatomical abnormality. Yeah, I guess you could certainly use that. So if you've got a doctor saying that you meet 1.18, you basically are not a surgical candidate because of the subluxations or going out of joint, and there's a lot of pain involved in it, and you're not reliable. Yeah, I think that you certainly have an argument there. And again, that's the one area that I've consistently won cases in that are younger claimants. If it's severe, not every Ehlers-Danlos case is the same level of severity, but if it is severe, that's a very good argument to make. I think 1.118. Okay, let's see here. Where are we? Okay, I am. Okay, here we go. All right, so we've got about 10 more minutes here. So let me kind of zoom through some of these. All right, GC Styles. Who determines your RFC? What factors determine sedentary? Well, RFC stands for residual functional capacity. That is a legal determination, not a medical one. It's a legal. That's why I call these forms FCE forms, functional capacity forms, instead of RFC forms, because a doctor can't decide your RFC. Residual means leftover functional capacity. So it means what is your capacity, what's left over after you take into account your medical problems. So the judge decides the RFC based on the medical evidence. And sedentary basically is defined as standing and walking no more than 2 hours in a workday, lifting 5 pounds frequently, 10 pounds occasionally. That's the definition. And again, the medical doctors can say, or actually go to a physical therapist and get a formal functional capacity evaluation. That could limit you to sedentary, or a doctor can do it in a form as well. But that's a medical determination there. Let's see here. I thank you, Christina. Please, yes, I'll put that on the banner here so you can see that. But yes, please leave me a review. That is always very, very helpful. All right. What about a person with fibro? Again, fibro, I think fibro can be extremely painful and debilitating. It's just that you can't image it. There's no X-ray, there's no MRI, there's no CT, there's no way to prove that you've got it. It's all self-reported. It just doesn't play well with Social Security. They like objective evidence. 54 years old, ruptured disc in the neck and back. Yeah, I think you're asking will the grids apply? Yeah, 54 means the sedentary grid, very well applied, 9th grade. So you're going to be limited to, there's one for less than, a limited education. That makes it a little bit easier to win. It's going to be assumed that with a 9th grade education, probably not any transferable skills. So you would have to show direct entry into skilled work, which you probably can't do. So I think the sedentary grid would apply. Why did you get the letter changing to disability to retirement? That's because you probably turned 67 or so. Full retirement, it's basically they change it automatically. Sally, my pleasure. I'm glad to help. Okay, God bless. Well, I will take every blessing I can get. Thank you very much. Okay. Deb is asking, Jay, how old are you? Okay. Stephanie's, yes, Stephanie is. It's one of the really nice things about this practice. I got to meet some really nice people, Stephanie being among them. It took you off disability. Again, if you are at retirement age, they'll move you automatically. Okay, so Louis says that a CDR was done exactly 3 years. So again, that can be the case. I'm not seeing it to that extreme every time, but I guess it could certainly happen. Hello, JX. John Xavier, JX. Yeah, FRA, full retirement. You're no longer disabled, no more CDRs. Yes. Yes, Marie, you're welcome. Just has a physical exam. JX is asking that he applied for disability based on PTSD, but they gave him a physical exam. The adjudicators can send you out to any kind of exam they want. They're trying to develop the records. So maybe there was something in there that suggested you've got some physical issues, but it can't really, at worst, it's going to just be a nothing burger, because the physical exams are pretty useless, but sometimes you get something good out of them. So it's probably not the end of the world. Marla, you are welcome. Okay, so let's getting close to the end here. Remember, next week it's going to be on Thursday, not Wednesday. Okay. All right, how do you do? I'm coming to a year since what you're hearing, and one, have yet to receive back pay. Reach out to the attorneys and told to wait. That's too long, a year. This is when you contact your elected representative. Say, hey, something's going on. What's going on? That's too long. There's got to be a reason for that. Okay, emojis was what I was thinking about. I kept calling them something else, but Garrett had some emojis. That's what I was, sometimes the brain doesn't always click in, but emojis. Think about it. Some of these words, you think back 20, 30 years ago, when I first started an emoji, what's an emoji? But you gotta go with the times. I don't know. That's a very good question, G-Man. How do you appeal that? what's good enough reason to have excess funds. Greg Brinkley might be a resource for you. Reach out to Greg at gregbrinkley.org, I think, and ask him. I don't know. That's a very good question. Okay, so Amanda, this is unusual, but good for you. You're 38, just won your case for fibromyalgia. Hey, very, very unusual, but don't look a gift horse in the mouth. That's awesome. You're supposed to say, go Falcons. Thank you. I appreciate your time. Okay. Well, the Falcons have been making some moves recently. They made that crazy draft pick, in my opinion, where they picked a quarterback when they just signed Kirk Cousins. But large overpayment, yeah. They could be taken together because they may be the same thing. I mean, as overpayment could be, if you're getting SSI when you had funds in the account, it would seem to me that they would be the same issue. So yeah, they'll be considered. Thank you. I appreciate that. I don't know if your name is Daryl or there's something you do Daryl's cover, but thank you very much. I appreciate that. Okay. All right. I got some interesting, I don't know what that emoji, oh, it says shaking of the hand. Okay, I'm seeing it larger on the screen here. But Ayamuth Paul says, I'm golden. Thank you. I appreciate that. I guess that's a good thing. I don't know. Okay. Actually, it's next Wednesday. I'm going. Okay. The reception is cracked. I'm sorry about that. I don't know. Okay. No one else is complaining, so maybe it's you're in. I don't know. Okay. Uncle Buck's quarter. Can you get on SSD after 4-6 and scoliosis? I think that 4-6 and it's caused by scoliosis would suggest a very severe level of scoliosis. And if you've got other issues, I want a case for a young lady who's a college student, part-time with really bad scoliosis. It can cause a lot of problems, as you well know, cause some problems with internal organs and so forth. So yeah, it can be really bad. Okay. Now you can ask, by the way, Jay, I think you can ask that they continue to pay you benefits while you appeal, but there's only like 10 days to do that. So that's really limited there. Okay. All right, I'm going to take a couple more of these. My past job, good Jim, DOT requires light work and a GED. You have a GED or a ninth grade education. Yes, that will help. That will help us, yes. Because you're past, part of the thing, step 4 of the sequential process is proving we cannot return to past relevant work. And if you're past work, you cannot, and again, if what you're saying is that you did a job that you were technically not qualified for, I think you can make an argument that you could not return to past work. I think that's what I'm hearing you say. So yeah, I think we could do that. Okay, Jim thinks it could be. It could be right. Could be right. Okay, under 55, you don't get a sedentary or no work. The word, yeah, 55 or under. Yeah, 55 or under, you want to get to that sedentary RFC thing. Yeah, sedentary, because if you look at the grid rules, under 50 to 55, you have to be limited to sedentary to make them apply. Over 55, you can still win it light. That's what makes 202, I'll close on this. That's what makes 202.06 so powerful. Because basically, if you can show, even if you could do light work is standing and walking 6 hours out of a day, lifting 20 pounds occasionally. Even if you can do that, you're still disabled. Most of the jobs in the DOT, a significant portion of them are light jobs. So even if you could do most jobs, you're still disabled. Or put this another way, Social Security would have to prove you can do medium work. Medium work is lifting 20 pounds frequently, 50 pounds on occasion. That's difficult for many healthy people. So 202.06 is it's a golden ticket, in my opinion. Really, really powerful tool, and I use it all the time. Okay, all right, I'm going to close this now because it's 10:30 my time, and we are at 2 hours now. Again, just a quick reminder, next week, this will be on a Thursday, not on a Wednesday. If that should change, I'll post it, but look for the post in the YouTube channel, the Facebook page, and LinkedIn. And hopefully I will see many of you here next Thursday. And after that, we'll be returning to our normal Wednesday time slot. But I believe I'm almost I think it's the 13th. I think it was, or the 11th rather, September 11th, which obviously is a day most people, think about. I think that on September 11th we have these tickets. So hopefully we'll have a nice time. I'll tell you all about it on that Thursday. And again, for now, thanks everybody for your time and spending your evening with me. And we will see you next Thursday. So thanks everyone. And good night.